Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency wise or relevance wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of? Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements,
Right.
and we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad, and then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge,
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those two.
right. It's the
Okay.
whole state.
No, it's not just those two.
Right.
It's
And so,
my understanding is the state is saying, I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking a stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. when he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, you're on trial. So.
Right, but they're co-indictees.
Yeah.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements?
No.
Or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who were not indicted, that fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical, the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mm-hmm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of that. The shooting of the convenience store on Cleveland, I'm just making this up, Cleveland Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that
and
what you want to know so that we can then drill down on, is there any basis for that coming in?
Right. I
Is
need
that
to
what you
know what
mean?
the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
Your Honor, I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost, and then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it. Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats, charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle. Sorry, I apologize, Ms. Winfrey. Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022
Could you give up your coffee for a cup of mushrooms? I did, and it's the best thing I ever did for my health and well-being. Rise is a wonderful blend of 6 organic superfood mushrooms in every sip. It works magic to heal me physically and mentally. Everything from better energy and focus to deeper sleep, a calmer gut, and overall immune support. Every sip gives me exactly what I need to show up as my best self every single day. I love the creamy, bold flavor and how smooth it tastes. Rise Mushroom Coffee truly brightens my mornings. Try it and feel the difference for yourself.
Theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity are up. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There
Okay.
are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252, 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723
Okay.
at 734. It's a 2015 case.
Okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, said in order to save, or that it is a constitutional statute, because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang.
Mhm.
That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks it, 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
they didn't take it up.
They didn't take it up,
I
okay.
didn't get under Dukes, D-U-K-E-S. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and,
Did not, they said it's not a collateral order. I
okay.
needed a
All right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And then
Okay.
they dismissed the appeal. So there's no
Right.
rule of the case.
Okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promised that.
Okay.
in those two
And
counts.
are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an
Okay.
essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12. But hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment. But no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count 1.
Okay.
RICO conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who are here, also
Mhm.
the others who are not here,
Mhm.
unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity
Mhm.
in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, which is 342 Georgia Appeal, 569, it's in Division 2,
Okay.
the 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case.
Mhm.
The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is MC-ARTHUR versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is W-Y-L-I-E versus Denton, D-E-N-T-O-N, which is 323 Georgia Appeal 161. It's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, S-P-A-C-E, comma, Inc. versus Dan Tanners, D-A-N-T-A-N-N-A apostrophe S, CNN Center, LLC, and that's at 349, Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mhm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. And that's in Eubanks, E-U-B-A-N-K-S versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, H-E-A-T-H. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay,
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached. So
sure. Yeah, and if it is already in writing, I'd love to have that. And
I will send
has,
it to you.
I assume this
this-
got argued at one point before if the
Yes,
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order,
Okay.
and I filed that in a motion that I gave to this honorable court.
Okay,
I'll get the motion, I attached
right.
it, but I didn't give you my brief. So the court's permission, and of course, the state has it already, but I'll resend it.
is it filed in the case somewhere or?
Went to the Court of Appeals.
Okay, that brief.
The whole-
Yeah, sure.
the whole brief.
I'll take it all.
Okay.
And
there's-
then I'll assume the state filed some sort of a response, maybe not this team right here, but,
They-
and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order, it's
Yeah.
12 pages.
I'll take all of that.
Okay, so I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay, thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was
From-
held on November 20th, 2023.
Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you, appreciate that. All right, Mr. Harvey, you look like you also were maybe gonna stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time
Okay.
to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I can write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for like, I mean, I know like if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about like overnight that is different?
Only for the defendant
Okay.
and the defendant's counsel. That was the whole basis of Perry versus Leak.
All right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case,
Okay.
not from within Georgia, but it literally spoke directly to it. So I was at
Okay.
least looking for that.
All right.
Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right. Attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's
to the court.
make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank you all. We're going to take a recess right now. If there's not anything we can do immediately, And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right, that there was a new Rule 22 filed? Okay. All right.
Joke, no joke. We in the building. You already know. Was good, was good. Instead of me starting it over, I'm just gonna wait for her to come back. All right. That's about 15 minutes. She's a little prompt with hers. All right. So I'm gonna play a little something for y'all until she come back from the commercial break. Shout out Swag and Kicks in the building. Steven, what up? My dog in the building. Beauty of God, Michelle Jensen in the building. Shout out to all y'all. CC Crippen, Don K, Kim Gaines, what up? I see y'all. Joke, no joke, man. I'm here, man. I'm here. All right. Let's see. Take it back. Let's see. What can I play while the judge is doing her thing? Trying to see what I could play for y'all. Try to go dig in the crates.
This is your team. We have the right set of individuals. They're going to take us to the next level. Hard Knocks training camp with the Chicago Bears, streaming exclusively on Max.
Trying to dig in the crates and play something for y'all. Should I play? Y'all got any requests? Pick a year. Let me see. Nah, not that. Let me see. How about the old Rockefeller joint? I was in the studio. See if y'all recognize any of these people. I'll play this until we come back.
Level 8, some shit like that. You gotta do the damn thing. Hello?
Jarrell's a live wire. You know what I'm saying? Jarrell conscious.
So we gotta
Jarrell crazy. Yeah.
All right, for sure. All right, so let's keep it moving. All right, handle with y'all. Get in the spot. We gonna fuck with you, but make sure it's super dope, super duper dope fresh. You know what I'm talking about? You already know. You already not do you. Don't ever listen to me. Listen to me. Listen to me. You know when you out of line, nigga. But don't ever not do you, nigga. Because I love that nigga Tone Hooker. No homo pause, all that shit that he said.
Yeah, that's my word. That's my motherfucking brother from another mother, yo. Straight up out of all this time, that nigga came in the game.
Maybe y'all a drink.
And now, that shit was like fertilizer, pause. Now nigga about to fucking blossom. You know what I'm saying? Nigga about to fucking blossom. I'm on my grizzly right now. Thanks to the king.
And your fourth drizzy.
That's my second drizzy, nigga. Watch your mouth.
That's you guys on that. They gonna be on that.
Nigga, I can't wait to record that motherfucker tomorrow. I'm tired.
Oh yeah.
I'm dead at.
Oh yeah. That's gonna be some crazy shit.
Yeah, we gotta open it, man.
That's gonna be crazy, yo.
You got to open it. So, where you
Yo. That right there, yeah, y'all was laughing. Y'all had him picked. Whoever he is, y'all had him picked. I know you did. It's okay though. All my real live fans are still around. You know what I mean? It's time now though. Hope you got your money stacked up. Rockefeller, homie. Y'all know. I don't even gotta say it no more. Y'all been waiting, walking on safety pins. I've been hearing, wanting to know what I'm doing. I'm knowing. It's cool. I got my squad with me now though. It's a wrap. It's a wrap. We're gonna tie this whole game up in a bow. For real. Real. Rockefeller style. This is real. That's the last time I'm gonna say that. Y'all gonna know it from here. All right, so homie. I ain't gonna even mention it because niggas might try to steal him. But one love to my boy and his mans over there in the cut, holding me down. Yeah. That's how we keep it around here. Secret society. Aliens. I don't want you to know nothing until it's time for you to know. Yep, y'all did it to me. Don't blame me. You know what I mean? Rel took over my life. I'm sorry. You know, Rel's just in the cut now. Rel's here all the time. Deal with it. Because I ain't leaving. I'm not going nowhere. We too strong now. Y'all know. Rock Army. And I'm definitely a part of the Army.
Joke, no joke. I'm here. You know, it's a little throwback, some. Y'all probably never seen, or yeah, I don't think y'all ever seen that. I don't think I ever played that. Hmm. I got another flashback for y'all. This one goes out to the ladies. All right, they ain't come back to court yet. Hold on, I got y'all. Y'all ready for another exclusive? Never seen before. Let me see who the first person can name this person. First person in the text, in the chat, name this person. Let me see how y'all know y'all history. Y'all ready? Let's go. So I got content for decades, all right? Not years, decades. Exclusive. Y'all see how long I've been doing this, man. Y'all see how long I've been doing this. Niggas ain't got, they can't, you tell them, Steven, the content king, all right? They don't know. Choke no joke, B. Crazy? Foxy Brown, what up, Boogie Brown? Y'all let her know. Cho got that exclusive of you. Rest in peace, DJ Mr. C.
Applaud for throwing this event, and thanks Foxy Brown for coming through. One more time, make some noise for Foxy Brown, y'all. All right. Brooklyn's illest female MC, all right? Don't get it twisted. All right, we're about to be up out of here. If y'all, we get ready to leave, so y'all have to start leaving. All the boosters, we see y'all. All the boosting cats, you're gonna have to start proceeding out. Cameras is on, and you're gonna have to start leaving. If anybody wants tickets for Miss Jones' party Sunday, she's still here. If you want to buy tickets for her party, Miss Jones still in the house. And don't forget to pick up Foxy Brown's album, China Brown, and her first album, Il Nana, in stores now, all right? And we are out like a light.
Good morning. Because the body is a God-given beautiful thing, and I think it should be praised. Every woman is sexy in their order to Foxy Brown. Being sexy to me is being free, able to express yourself, whether it's fashion or fun, just being able to open up and live and being open to criticism and different things. Able to feel sexy whether you're in a sweatsuit or some sweater, just being sexy. Very cool to me. It's a good thing. You're edgy. Not afraid to take chances and not afraid to fail. Being an author is not fair. You get up and get it again. And that gives you so right.
34th Street, New York, Manhattan, Herald Square. Choke no joke. I was everywhere. You was never there. All right? They didn't come back in court yet. We still waiting. Y'all need another flashback? Oh, they back in court. I heard them.
Afternoon.
Oh,
All right,
Caleb Bumpus.
so you filed a Rule 22 at what, 11:10 or so? That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes,
live stream. Miss, what is that person's name?
Miss Sylvia.
Miss Sylvia.
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to any kind of opinion that you want to about the case, and you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time, they can say it's copyrighted and take it from me. Or
Okay.
from my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay, would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today? Or
Yo,
did I give
she's a
everybody enough
joke.
work that y'all
Yo,
can just
she's
go
a
home and do
lawyer?
work, and y'all gave me plenty of work to do also. All right, so we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence. Okay. All right. Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No?
We're coming up on a major fundraising deadline, and there aren't many more. But
No, lady, you got the wrong channel. No, lady, we got nothing for you, Miss fake black lady. Sorry. No, we got nothing for you. No money here, lady. Sorry.
Did we ever get an answer, Judge, as to whether or not we have the transcripts from the 10th? I know that Ms. Weaver indicated, excuse my seat. Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today, is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
Yeah, I can't believe this girl Kayla's Bumpus filed a motion so she could film in the courtroom, bro. Like, yo, bro, she talking about getting copyright stricken on a public trial, bro. And she says she's a lawyer. So she got time to go watch this trial every day and report on this trial every day.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have. Now, this isn't his testimony. This is y'all going through evidence, but y'all should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So